It's closing time in the dating app murder trial. The prosecution had the first word. Now it is the defense's turn. Here we go.
You may be seated. Mr. Norgard, what says the defense?
Ready to proceed, Your Honor. Thank you. Good afternoon.
Good afternoon.
Love that guy. Two sides to every story, right? And oftentimes when you only hear one side of the story, you can be misled into the wrong conclusion, and when you hear the rest of the story, you find out that you're going down the completely wrong trail in your thought. I'm going to make two observations as I begin my argument. One of the things that the prosecutor emphasized to you and tried to make a big deal about was when Mr. Warner was stopped by the police, that he said he didn't know Ms. Bustos' name. And let's clear that up right at the beginning. Mr. Warner told you and testified that she was introduced to him as Rose or Rosie. The police are asking him about somebody named Hilarie Bustos. He's able to figure out they're talking about the person who was in his car that fled from the police. But he wasn't trying to distance himself from Hilarie Bustos, because despite the confusion over the names, what did the law enforcement officers tell you? They had no idea what apartment she might be in Boudreaux Court. They'd actually gone there at one point a couple days before trying to find her there and couldn't. They didn't know which apartment she had gone to, which apartment that car was coming from. Who told them where she was? Mr. Warner. He told them where Hilarie Bustos was. Yet the state wants to try to argue he's trying to distance himself from her. That's not what the facts were. The second observation that I would make is that during the course of the prosecutor's closing argument, she kept saying, "We know, we know, we know." Anything that was in the least meaningful, the only time and only context when Mr. Warner's name would come up was always preceded with, "We know because Haley said," "We know because Josh said," or "We know because Denzel said." Everything that we supposedly know hinges on the credibility of those three people. As I get into talking to you about the case, I'm going to thank you in advance. This has been a long 3 weeks, and little did we know we'd find ourselves in the position we're in with everything going on the outside. But I have 100% trust in y'all. I mean, I've watched you. I've seen the way you've gone about your business, the way you've gone about your job, and I really want to thank you. Thank you on behalf of Mr. Chastain, but more importantly on behalf of Mr. Warner. This has been an emotional experience. I think you would all agree with me on that. Some of the emotional aspects of this case just come out at you from left field. I mean, places you never even expected to deal with emotion. But I've watched you as you've dealt with the emotional aspects of this case, and I can see your concentration, I can see your focus, and I know that you're going about your job the way that you need to do it. And I think examples always are the best way in a lot of instances to explain things. I think we had a good example of this with the 911 call. Mr. Hunn is hysterical, reacting to the situation that he was dealing with. Did you hear how professional that 911 operator was despite the emotional aspects of what she was dealing with? Another example, Chris Rogers, all he had to do was look at a shirt with blood on it and start crying. Dr. Volnick is going about her job presenting much more graphic things than that in a very professional, rational way. We're going to have emotions, but I have 100% confidence that you're going to move forward in your decision, making a rational and legal decision, a decision that's based on careful analysis, comparison, and evaluation of the evidence. And I thank you for that. As I said at the very introductory portion of my argument, the state's case revolves around the credibility, or from my standpoint, the lack of credibility of Haley Bustos, Josh Ellington, and Denzel Rakowski. The first part of my argument as I go through, like you're required to do as jurors, to carefully analyze, compare, weigh the evidence. I'm going to talk about some aspects of their credibility that are of a general nature. Then I'm going to talk about aspects of their credibility that relate to the facts of this case itself. You're going to be given a jury instruction that, frankly, it starts out talking about common sense, and I think most of what's in this jury instruction is common sense. Part of what your job is to weigh the evidence, to evaluate the evidence. So make sure you take a close look at this instruction, because this instruction tells you how to weigh the credibility of witnesses, how to evaluate witnesses. And very honestly, I give jurors a lot of credit, because you may not have been able to spell these out, just 1, 2, 3, 4, 5, 6, 7, 8, 9, some of the side parts to it, but what do you do when you're trying to figure out if somebody's telling the truth or lying? You use your common sense, right? What do you do when you try to tell if somebody's lying? You look at how they acted, right? You look at their demeanor. Y'all know that. But this instruction very succinctly puts it out there for you so that you can use these tools and apply these tools in evaluating the testimony of all the witnesses, but more particularly, the three whose credibility has frankly been demonstrated to be lacking. You'll look at all these different factors, and as I go through and talk about these three people, I'm going to be hitting upon some of these factors. I'm going to rely on you. We got 12 people that are going to go back and make this decision. You guys have pretty much been here and seen what I saw. You have your own memories, your own experience. You have 12 people to remember what you heard. To a large extent, I'm going to rely on you guys. I'm not going to sit here and try to quote every word every witness said, because you heard it. But I do want to go through and just briefly discuss the different aspects of weighing the evidence. Rather than a phrase that the prosecutor used repeatedly of, "we know because Haley Bustos said," a lot of what I preface a lot of my stuff with is going to be, "we know this because of common sense. We know it because of common sense." Use that. That's what a wonderful tool. And I know y'all have that, and everybody here. The other thing that you can look at is how the witnesses acted. And all 12 of you, all of you up there, 12 jurors ultimately decide the case, but as you watch those witnesses, I'm asking questions, but I'm also looking at your reactions. I'm seeing you watch how the witness is acting, drawing your own conclusions about what you saw, about how the witness acted. One thing that just stood out in my mind is at one point I got Haley Bustos to finally admit, "Yeah, I'm looking for the best deal I can get." And I could barely hear her response when she acknowledged that's what she was trying to do, and I asked her to repeat it, and she just completely shut down. And I asked the question about 3 different ways, and I finally gave up. But you can look at their overall demeanor, how they acted on the stand, and it'd be a good way to kind of go about doing that. Look at the other witnesses. Look at how Denzel Rakowski acted. Look how, Josh Ellington acted. Look like Haley Bustos acted. Compare that to these other witnesses who just came in here and are like, here, I'm here to tell you this, I'm here to tell you that. Compare the behavior of those 3 people to the demeanor you saw of the other witnesses whose credibility clearly isn't an issue. They were just coming in to tell us what they knew. The other thing that you can look at is, was the witness honest and straightforward in answering the attorney's questions? Rely on recollection. When Josh Ellington was up there, when Haley Bustos was up there, when Denzel Rakowski was up there, compare how the witness acted when it was the prosecutor asking the question. But look at how they acted when I was asking the question. Valid questions that help develop information you need to know about these people. Look how they would treat me as the questioner versus the prosecutor. But the prosecutor, they're falling all over themselves to help her out, or help him out if it was it was always her. But when I was asking the questions, I could ask them, hey, is the sun out? And they'd be trying to figure out some way, where I was asking that. And look at how they acted when I asked the questions. You can also compare that to the other witnesses. But even Mr. Warner, when he was answering questions for me, answering questions for the prosecutor, there was no difference. Just like the other witnesses, whose credibility isn't an issue like these 3 people. Look at how they acted. Mr. Warner told you about his 3 prior convictions for felonies, and that's part of what is, he carries with him in his life because of those mistakes. But you also look at the other witnesses called by the state. Josh Ellington, 7 felony convictions, 3 misdemeanors involving dishonesty. Mr. Rakowski, 3 felonies, 2 misdemeanors involving dishonesty. And even Miss Bustos, who had no convictions, you found out she was on probation. She'd committed another crime with Mr. Ellington. Factor in that as far as their credibility. Another thing that you look at is, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? We're not talking about people who, when we're talking about Rakowski, Ellington, Bustos, we're not talking about people who came in here and said, oh, I thought his shirt was red, but now I thought about it, it's blue. Those people, all 3 of them, were questioned by police officers. Ms. Bustos was the first one in time questioned by police officers, and I would disagree with the state when they said that she quickly told them the truth, or at least what she claims is the truth. It went on for about 25, 26 pages of her maintaining that she knew nothing about this. She went on the date with the guy. That she even talked about acting jobs. Oh, why are you asking me about Adam? Did something happen to Adam? That was the kind of game she was playing with the police, pretending like she didn't even know he was dead. And think about that for a second. 18 years old, being questioned by the police about a murder. And she's cool enough in the story that she's telling to act like she didn't even know he was dead. And can I ask, can you please tell me about what's going on with Adam? She had already sent 2 texts. One in the morning, one at 7 o'clock the next evening after he was already dead, to make it look like she didn't know he was dead. That was the extent that she was willing to go, to say she knew nothing about this. Josh Ellington, he went through an entire police interrogation, denied knowing anything at all about this. And even Ellington told you how the police, and I brought this part out about how the police even commented about how cool he was during a police interrogation about a first-degree murder. Denzel Rakowski, the police find him pretty much right after this happened. Mr. Rakowski went through an entire police interrogation, maintained he knew nothing about this. He even said that he had left the residence before noon, the night that Haley even went on the date, and before the early morning hours when the crime occurred. The whole police interrogation, maintaining he knew nothing about this. When Mr. Rakowski found himself in a position to give a second statement, remember my questioning of Mr. Rakowski, and I'll talk more about this later. The police officer, I'm here to, first words out of their mouth, I'm not here to get you in any kind of trouble, but I need you to tell me what you know about this case. Don't know nothing about it. The prosecutor, she was in here talking to you. She can change her mind and charge you as an accessory. I don't know what you're talking about. That went on for page after page after page of him being told, you can either be a witness or you can be charged as an accessory. Ultimately, the officer told him that one more time and said, if you tell us what you know, you won't be charged. But the flip side of that coin, the unsaid message being, if you don't tell us what you know, or if you don't tell us what we want to know, you're going to be charged. And it was only then that all of a sudden, after making at least 10 or 15 denials, how can I tell you something I don't know about, that he then claims to know something about this crime. So, one of the other factors that you can look at in evaluating the credibility is any pressure or threat been used against a witness that affected the truth of a witness's testimony. My gosh, use your common sense. You can either be charged as an accessory or tell us what we want to know and be a witness. That's the position Mr. Rakowski was put in after being repeatedly told that. Even Miss Bustos talked about how she's trying to spin this story, that she knows nothing about it, that yeah, she went on the date, but we had text afterwards. But the police kept questioning. They started asking her about the evidence in the case. And it was only under that pressure that she says she changed and gave the other story. Mr. Ellington was under a different kind of pressure. He told them he didn't know anything about this. And he's sitting in jail facing a first-degree murder charge in life in prison. The other thing that you can look at in evaluating credibility is, has the witness been offered or received any money for preferred treatment or other benefit in order to get the witness to testify? All three people. Ms. Bustos, despite initially claiming that she's here because out of the goodness of her heart, it comes out that she's entered into a proffer agreement, that the proffer agreement contemplates full and complete cooperation with the state attorney, that if there's not full and complete cooperation that rises to the level of substantial assistance, she's cooked. She's facing life in prison. And who determines whether there was substantial assistance, substantial performance on their behalf? The state attorney's office. People calling them as a witness. So not only is there the benefit out there by testifying, the benefit with which Ms. Bustos finally admitted the reason she is doing it is because so she can hopefully get the best deal she wanted, that she could get. Mr. Ellington was at least straightforward about that and said the reason he's testifying is that it's his one lifeline to avoid life in prison and get something better than life. That was his lifeline, and he's hoping for the best deal he can get. And what's crazy about this is the person with the least exposure, he's looking at 15 years in prison, Mr. Rakowski. When I asked him about why did they continue your violation of probation hearing past Mr. Warner's trial, his first response was, I don't know. My lawyer did that. And I said, well, isn't it your input and your decision as to what you want to have happen in your case? And he says, yes. And if you'd wanted to have that case disposed of on that day and not put it off till after Mr. Warner's trial, you could have done that. And he acknowledged it and then says, but I haven't got the deal I want yet. And unfortunately for those people, it's the hope of getting a benefit, but the pressure, if it doesn't rise to the level that the state likes, they're not going to get the benefit. The old carrot and the stick. There's another jury instruction that goes on. If you already didn't have enough information on how to evaluate credibility, got a whole other page for you. Included on there is treat law enforcement officers just like you would any other witness. Treat the defendant, the guy accused of the crime, treat him like any other witness. Guess who doesn't get the benefit of being treated by any other witness? Somebody who's an accomplice. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime and hopes to gain more favorable treatment in his or her own case may have a reason to make false statements. I don't think I haven't even had to read that to you, and you guys know that just based on common sense, that someone claiming to be involved in a crime that's hoping for more favorable treatment, gee, is there a chance they might make a false statement? Huh. Common sense, even the law tells you that, to look for that. And so with that in mind, let's move in. That's some more general credibility things, but let's move into the facts of this case. First of all, the three people that we're talking about. What is their interrelationship? Josh Ellington and Haley Bustos are very close friends. They're such close friends that when Mr. Ellington asked Haley Bustos to beat up a girl for him, that she beat up a girl for Mr. Ellington while Mr. Ellington stood there and watched her beat up the girl. That's how close their friendship is. They've committed a crime together. That came out in the evidence. Denzel Rakowski is Miss Bustos's girlfriend at the time, boyfriend at the time. And what about Miss Belmont? Miss Belmont was not a witness in this case, but as you heard in the evidence, Miss Belmont's the one that set up the Plenty of Fish account, was teaching Haley Bustos how to make money without spreading her legs by going on this account. Miss Belmont, whose name was prominently featured in this event, what was her relationship with Miss Bustos? This is where it gets a little weird, but they were having a sexual relationship, and Miss Bustos also had a sexual relationship with both Miss Belmont and her boyfriend. But all four of these people are tied into each other. Mr. Warner's just kind of floating around on the edge of the scene. He's hanging out at the house, but he has no in-depth interpersonal relationship with any of these people. And that's what the evidence is that's before you here. The prosecutor talked about this portion of the instruction where it talked about, is there other evidence that tends to agree with what the witness is saying about the defendant? Think about what the prosecutor argued to you. Anything that Miss Bustos, Mr. Rakowski, or Mr. Ellington said about Mr. Warner, there's not any independent fact to support anything about the crime itself. Yeah, they went to a strip club together and the phone was there and there's text about going to the strip club. But what does that have to do with the crime itself, the event itself? Look at the things the prosecutor was trying to say corroborated Miss Bustos. And it either is inconsequential facts or things that only have meaning if you base on what the person said. What I'm going to do is I'm going to go through the facts which show Mr. Warner's lack of connection in this case. As we go through and analyze the other evidence in the case, there's two instructions that somewhat relate to that. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness's testimony agree with the other testimony and other evidence in the case? Let's start out by using common sense and analyzing the testimony of these three people. We know from our common sense that when somebody tells a lie, they're not just going to completely make something up that doesn't have some basis in fact. Anytime somebody tells a lie, there's some things that they may be very well talking about that are true, but then they can weave in the fiction with the fact. And, it makes you start to think, well, maybe they know what they're talking about. But when it comes to backing up fact and fiction, it's, inconsequential facts that the state pointed to. And there isn't anything to back up what they're saying. There's an opportunity to lie that's built in with an opportunity to see and know things. The other thing that happens when people tell lies is that it would be nice if you had three people that were going to tell you a story. Something happens, you're able to immediately isolate them, get their stories from each other, and then compare them against each other. That's a good way to try to figure out if somebody's telling the truth or not. What happened here? Ms. Bustos gives a statement to the police. Josh Ellington says he knows nothing about it. He reads his discovery and reads what Ms. Bustos says happened, and then enters into a proffer agreement and comes in and tells the same story that Haley did. Mr. Rakowski didn't come forward for almost 2.5 years. We didn't have that opportunity to get three people, separate them, get their story, and then compare them. Because guess what? They lied. They said they didn't know anything. 2 years passed, 2.5 years passed before we even get a semblance of a version from either of those two people. The other aspect of looking at whether somebody had the opportunity to see and know about things, whether their testimony agrees with the other evidence, Ms. Bustos admits in the proffer agreement. It was a question asked by her own attorney. He asked Ms. Bustos, is that that part of what she was doing was telling the police what they wanted to hear. That was her own attorney asking Ms. Bustos that question, and she admitted that, yeah, that's what happened. When she was talking to the police, the question was framed in your first statement, and particularly in your second statement to the police, in part, were you telling the police what they wanted to hear? And she said, yeah. She admitted that on the stand. And then my question to her was, well, what parts of your statement were true and what parts of your statement were things you thought the police wanted to hear? And her response, oh, I'd have to look at my statement. Like, we really want to sit here and have a witness that's already demonstrated this lack of credibility go through and say, oh, this is true, this isn't true, this part's true. She admitted she was in part telling the police what they wanted to hear. And guess what? Mr. Ellington adopted a story by somebody who admits that parts of their story weren't what really happened, but were what she thought the police wanted to hear. The other thing that came out through the questioning and testimony of Ms. Bustos, again, a question in the proffer asked by her own attorney. With respect to the first statement, and in particular the second statement, were you in part trying to minimize your role? Yeah, that's what she said, and admitted she was trying to minimize her role. And I said, okay, if you minimized your role, tell us the things you really did that you didn't tell the police because you were minimizing your role. She refused to do it, wouldn't do it, couldn't do it.
Folks, I'm sorry we got to take a commercial. We've waited long enough, but don't worry, you're not going to miss a moment. We're going to get you right back to the defense's closing argument in the dating app murder trial right after this. Okay, let's get you back to the defense's closing argument in Florida versus Andre Warner. We're going to pick it up where we left off. You haven't missed a thing.
When you go through and look at these credibility factors, what I've tried to do is I've tried to give you certain examples, some of the things that came out in cross-examination. I had no intent of standing up here and closing an argument and going through my entire cross-examination of Ms. Bustos, my entire cross-examination of Mr. Ellington, my entire cross-examination of Mr. Rakowski, because what I talked about to you just right now was the tip of the iceberg of what I brought out in their examination. I'm relying on you to remember those other things that I'm not up here specifically commenting about. Because again, I trust you. I trust you to go back there, do your job, and analyze their credibility, and look at the things that you saw and noted above and beyond what I've just, highlighted in this portion of my argument. So let's really, dive into what the evidence is related to the crime. Not whether they went to a strip club 2 days later, not whether they drove to Kissimmee, made a stop at a Family Dollar, but the facts surrounding the crime itself. There was a point, Plenty of Fish dating app. Where was that found? On Ms. Bustos' phone. All the contact information regarding Mr. Hilarie was on Ms. Bustos' phone. The entire set of physical evidence as it relates to the date and how it was set up is all found on Ms. Bustos' phone. When Ms. Bustos and the other people, Ellington, when we start to get into going to Mr. Hilaire's house, one of the first things that Ms. Bustos claimed about Mr. Warner is that when we went to get in the car, Mr. Warner asked them to pop, she said they asked them to pop the hood, that she claims he put something under the hood, closed the hood, and off they drove. She claims that when they got to Mr. Hilaire's residence, that Mr. Warner said, pop the hood, got something out from under the hood, closed the hood. That's not what the evidence shows. Did you hear one word from Josh Ellington, the driver of the car, saying, yeah, I popped the hood? Who's going to be the person that's popping the hood if anybody's popping a hood? The driver of the car. And not one word from Mr. Ellington about this whole popping the hood thing. You can make up what you want about somebody, but when it's not true, the facts start to fall apart. Gets even better. You know, I got a big chuckle about the state joking about fingerprints. It's like, oh, my CSI really fooled us. You know, fingerprints really aren't that important. Well, if I was the state, I'd be joking about fingerprints too. Because you know what? Gary Gray's fingerprints were on the hood. Gary Gray, not Mr. Warner. Let's start really talking about physical evidence, talking about facts. Ms. Bustos claimed Mr. Warner did it. It was Gary Gray's fingerprints on the hood and another person named Cedric Gardner, not Mr. Warner. Gary Gray. One of the other things that both Ms. Bustos, Mr. Ellington, and the prosecutor have glossed over, and we're going to start talking about common sense. How did the perpetrators get in the house? Think about that. How did the perpetrators get in the house? Is there anybody here using your common sense that thinks Adam Hilaire hears a knock on his door at 3 a.m. in the morning and just walks up to the door and opens it up, and here those people are standing there? Is there anybody here using your common sense that would think if Mr. Hilaire looked out the window or looked out the window of the door and sees two people out there he doesn't know, do you really think he's going to let them in? And if there was a gun, guess where that other door is? On the complete opposite side of the house. Out of there and gone. But you know what the evidence showed? When Ms. Bustos was on her date, she was there when Mr. Hilaire hid a key for John Hunn's use. A little minor fact that she admitted to. You heard a lot of facts, but the evidence that came out was that when Haley Bustos was there with Adam Hilaire on the date, she saw him hide a key for Mr. Hunn's use. What did Mr. Hunn tell you? That before he, sat out there for an hour, hour and a half, or whatever amount of time he said it was, he went to look for the key, and the key was gone. There were no signs of forced entry, according to crime scene investigator Della Valley, according to Detective Hilaire. Perpetrators had to have gotten in the house and a key is missing, a key that Haley Bustos knew about, that she made no mention of as far as entry into the home, and claims she never got out of the car and other than giving directions, that's all she did. There's a missing key for the dead person's house that Ms. Bustos knew about. There's evidence related to an electrical cord. I'm going to take a side step as to the testimony of the two experts. Mr. Noppinger testified that when he looked at the electrical cord, that he could exclude Mr. Warner as the source of the DNA on the electrical cord. But he could not exclude Gary Gray. Name just keeps coming back at you. Bustos keeps coming back at you. But not Mr. Warner when you go through and analyze the physical facts. Miss Samuels from FDLE said, well, it was past this line, but not this line, so I don't really feel comfortable giving an opinion on that. Mr. Noppinger had been doing DNA evidence before she even got out of college for 25 years. He set up 3 laboratories, Broward Police Department, the own private laboratory, and was hired by the State Department to set up a laboratory with international accreditation. And he said, you can eliminate Mr. Warner from the DNA on that cord, but not Gary Gray. We do know that a big TV was taken, a smaller TV, other items were taken. Items were put in the trunk. What does Ms. Bustos and Mr. Ellington claim? They claim they never got out of the car, that it was supposedly Mr. Warner and supposedly Mr. Gray who did this. Guess what? Guess Miami CSI gets it right sometimes, because there was fingerprint evidence on the trunk. And it wasn't Mr. Warner. The fingerprints on the trunk of the car were Gary Gray and Haley Bustos, the person who claimed she never got out of the car. Those were the fingerprints they found on the trunk of the car. Ms. Bustos and Mr. Ellington claim that Mr. Ellington never got out of the car. It is State Exhibit 195. This is a photograph of the interior of Mr. Hilaire's car. On that car seat is a grill case. Gold grills that people put in their mouth, have gold teeth for whatever reason. That's the case for it. The detectives told you there was gold grill in there. Guess what? Goes to the lab. Yeah, you don't always get a result. But when they sent that gold grill to the lab,
Judge, I would object. The facts of evidence.
Sidebar over the gold teeth. Okay, we are going to jump out, get a commercial in. We'll get you back inside. The closing arguments for Florida versus Andre Warner right after this.
Tonight on Court TV.
Andre Warner's taking the stand in his own defense, and tonight we'll break down the key points of his testimony.
Just the type of person I am.
Did Warner's own words help his case or hurt it? What are the biggest takeaways for the jury? We'll dive into today's biggest moments as we rapidly approach the dramatic end of this twisted death penalty case.
Closing Arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
we have the testimony given to you by Mr. Crawford. The testimony proceeded that preceded his giving a statement to the police was his writing a letter to the state attorney's office with information about a first-degree murder, where Josh Ellington told him about a first-degree murder and told him about Haley and his cuz, who has consistently been referred to as cuz throughout this case. Crazy cuz, Miss Belmont's cousin. 3 people. Ellington, Haley, and cuz. And what Mr. Crawford testified to you is that without any benefit, without any potential reward, he contacted the state attorney's office with this information and told the police that Lawrence Ellington, the person who said he never got out of the car, shot Mr. Hilarie. There was a little bit of confusion on his part about Dre or Gray. But when questioned, he thought Gray was the person. He said Gray was the person that Mr. Ellington was talking about, and was the person that was the cuz that he saw in court that said something about Mr. Warner supposedly having gunshot residue, but something that came from cuz, not Mr. Warner. With respect to the evidence after this crime occurred, what do we have in terms of the evidence connecting anyone to this crime? On Haley Bustos' phone, we find a text message to Gary Gray's sister with a photo of some of the stolen property, and it was Mr. Gray and Miss Bustos. We went to Gary Gray's sister's house, sold the Xbox, sold the games, sold the jewelry, and split the money. Once again, as we get through the chain of events, the evidence being presented in this case, it's Gray, Bustos, and Ellington, without any of these physical evidence items linking Mr. Warner to anything. Miss Bustos gave a story about the sale of the TVs, but we have some additional evidence about the sales of the TV. A text message. Bitch, this is Gary. Bitch, I just hit a lick. I just got some TVs and talks about selling them for a low price. Where's that information on? Josh Ellington's phone. A person who claimed that after this incident occurred that he left and pretty much stayed away. Yet, here's this information on his phone about selling a TV, where Gary says, I hit a lick, got me some flat screens for a low price, to somebody named Bobby, and a return text saying, I found me a buyer. A return text to Mr. Ellington's phone. When the police begin to continue to investigate the case, it's kind of ironic that the biggest break in the case came when Haley Bustos was in Winter Haven, and Winter Haven PD, Winter Haven Police Department, just happened to be looking for her, and they go to stop her, and she takes off running. When the police went to pull over Mr. Warner, what did he do? He stopped. He told them about loaning the car to Haley, and told them where they could find the girl he loaned the car to in Evelyn Belmont's apartment. was Haley Bustos that fled. When this all went down, Josh Ellington had to be tracked down in Winter Haven. Not only when they tracked him down in Winter Haven did they have to track him down in Winter Haven, they had to send in a canine to flush him out of the house. What did Mr. Warner do? He stopped for the police, told them where they could find Haley. And again, use your common sense. If Mr. Warner were involved in a crime with Haley Bustos and the police were looking for her, are you really going to point the police to where Haley Bustos is located, or is it going to be, I don't know where she is. She brought my car back and she took off. I have no idea where she went to. He pointed them to Haley Bustos. When Mr. Warner was stopped by the police, they questioned him. He was never taken into custody. He was allowed to go. What did he do? Gave him a phone number, told him where he's going to be. What did Josh Ellington do? He goes to Winter Haven where the canine has to flush him out. And the police call Mr. Warner and ask him to come down to the police department because he can get his car back. He goes down to the police department. Goes down to the police department even knowing that they'd gone and took Haley into custody. He goes down to the police department. They arrest him, but he went down to the police department. You got people who are minimizing their role in a crime. What does the common sense tell you is the best way to minimize your role when you know the police are onto you, but you want to minimize your involvement? You find a scapegoat. We talked about how tight Josh Ellington are with Miss Bustos, how tight they were in terms of their relationship. And they came up with the story about, oh, we just sat in the car, we didn't do anything. They talked about Gary Gray. But they had to have another person. Because there's no way. Common sense tells you there's no way one person did this while two other people sat in the car. And who was the perfect scapegoat? The guy sitting back at the house, which Mr. Warner told you he was doing, with the only people who could back him up. Miss Belmont, who's neck deep in it with Bustos and Ellington and Gray. Miss Belmont, who is Gary Gray's cousin, calls him cousin. Elijah Belmont, Miss Belmont's brother. There's some testimony that Lawrence Ellington was there. Josh Ellington's brother. Mr. Warner was the perfect scapegoat. There's one other thing that the jury instruction talks about. That's paragraph 2 that talks about, did the witness have an accurate memory? I'm not going to stand up here and say that something happens a while ago that you don't have to look at reports to refresh recollection, that you don't, there aren't going to be some memory lapses on minor things. But I am going to talk about something that to me was absolutely mind-blowing. The prosecutor, during the questioning of Miss Bustos, not my questioning, when the prosecutor was questioning Miss Bustos, she was asked, did Andre Warner make any statements about how the victim was killed? Ms. Bustos' answer, not that I can remember. When asked about Mr. Warner supposedly making any statements about how Mr. Hilarie was killed, Ms. Bustos' response was not that I can remember. The prosecutor had to refresh her recollection from her statement, and it was like, oh yeah, he said this, he said this, he said this. Yet when asked that question, without prompting, she couldn't remember it. Mark Twain, one of, I'm going to just go on a limb here and call him the king of common sense. Mark Twain said so many things that just made sense on the most basic, fundamental level. Mark Twain made the statement, when you tell the truth, you don't have to remember anything. And when I question Ms. Bustos about this, remember how she answered this. Ms. Bustos, you were able to tell us who was present on the day that you met Evelyn Belmont. She was able to sit there without any prompting, without any, I'm not sure, not any, well, I'm trying to remember. When asked who was there on the day he met Evelyn Belmont, it's like we went to her house, she was there, I was with Josh, I was with Florence, and we met Evelyn Belmont and talked about the other people who were at the house. She can remember that, but not what somebody supposedly said about committing a murder. She could remember what items she sold to Gary Gray's sister in order for her to make money. The Xbox, the games, she identified the jewelry, but she can't remember what Mr. Warner said to her and made the comment, well, it was a long time ago, when I confronted her with, how could you forget something like that? And she's like, I don't know, it just happened a long time ago. Remember her demeanor when I was asking her those questions, the way she responded to that and reacted to that. Like Mark Twain said, when you tell the truth, you don't have to remember anything. The corollary of that is when you tell a lie, you're going to forget. You're going to forget your lie. You remember what really happened. When you're making up things, that's when your memory gets flawed on major items like something such as this. Go back and look at the credibility of those three people. I don't even need to spend time talking about the credibility of Mr. Warren. You saw him on the witness stand today. You can take each and every one of those credibility factors, evaluate his credibility, and draw your own conclusions about what he said. Mr. Warner told you that he didn't do it. The prosecutor tries to make it seem like when he's confronted with evidence that couldn't possibly resist, that the things he says somehow makes him guilty. Think about that for a second. It was like Mr. Warner, I use the phrase the Twilight Zone even when I was questioning the detective. And she was like, we didn't take gunshot residue, yet his grandfather keeps insisting there was evidence presented to the grand jury about you having gunshot residue on you. Didn't even collect it, yet a grand jury's hearing evidence about gunshot residue. The prosecutor was trying to make a big deal when Mr. Warner explained to his grandfather, who kept talking about it, why there was no gunshot residue. And what the prosecutor didn't talk to you about when she was trying to say, oh, well, you didn't say I didn't fire the gun. He'd already told his grandfather that. There were 25 calls that they monitored. Mr. Warner told you that in the context of talking to his grandfather on this particular day, he'd already told him he didn't shoot the guy. He'd already told him that. So because he didn't repeat what his grandfather already knew, somehow that's like, like he must be guilty. And think about even the contents of it itself. Mr. Warner believed that gunshot residue only lasted for 24 hours. Only lasted for 24 hours. He wasn't questioned for well over 2 days. There was no gunshot residue anywhere. I even asked the detective that. I said, if Mr. Warner was even in any way concerned about gunshot residue, based on his belief of a 24-hour time period, it would have had to been something that happened Saturday afternoon to Sunday afternoon, not early morning hours of Friday. Mr. Warner had already told his grandfather he didn't do it. And you can listen to that tape and hear how they're trying to figure out why they would even have this evidence. The conversation about the tattoos and whether that had anything to do with it. And his grandfather saying, well, Mendy said it didn't have to do with the tattoos. That was all in the context of that phone call. And to try to analyze and figure out that Twilight Zone moment of how could they be saying there's gunshot residue of it, but they didn't even do a gunshot residue test. How mind-blowing would that be to be sitting there in jail, being indicted, and being told there was evidence that couldn't possibly exist, and trying to figure out what the heck was going on. At the conclusion of the evidence, the court will read you an instruction on plea of not guilty. Reasonable doubt. Read that instruction. That is the bottom line question here in this case. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond a reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. Quite a mouthful. Simple way of putting it, one of our judges locally here used to do this. Are there reasons to doubt? Are there reasons to doubt the credibility of Rakowski, Buscos, Ellington? Reasons to doubt. That doubt can arise from the evidence, conflicts in evidence, lack of evidence. Counting on you, and I know you're going to do this. You're going to carefully consider, compare, and weigh all the evidence. And the way this works is, unless you have an abiding conviction, whoever uses that word, abiding conviction of guilt, how many of you ever use the word abiding? What that means is that, that belief is so fixed that when you examine the facts, the evidence, it's just unshaken. An abiding conviction, one that regardless of how carefully you compare and weigh the evidence, you come to that level of a conclusion. On the other hand, you could have an abiding conviction that Mr. Warner is not guilty and look at the evidence and walk away going, gee, boy, we looked at all these facts. These are reasons to doubt. These are reasons to doubt. And you could have an abiding conviction that he's not guilty. But there's in-between area. You look at it one way and it's like maybe he did it. You look at it another way, maybe he didn't. And you're going back and forth. Guess what you're doing? you're wavering and vacillating. You look at one thing and you say, well, maybe he did it. You look at a bunch of other things and it's like, well, I have some reasons to doubt because of this, this, and this. And you're going back and forth. That is a verdict of not guilty when that's the position you find yourself in. I did not make any kind of effort to go through every single item of evidence, every single aspect of the lack of credibility of these three people. I did not do that because it's your job to go back there and do that. You paid attention, you took notes, you used your memory, you developed impressions of those witnesses. Go back there, make sure you understand the law, follow the law, and you'll be in a position to make the right verdict. Thank you very much.